I'm Dr. Barry, licensed psychologist, and here I share legal and entertainment news from a psychological perspective. So, as I speak right now, the jury in the Chad Daybell case, they are coming back with a verdict. So, we are going, and I do not know what's happened. We are going to go straight to that to be able to hear what the jury in this case decided. So Chad Daybell was found guilty on all counts of murder related to his wife Tammy, to Tylee, and also to JJ. He was also found guilty of a conspiracy or fraud charge related to the insurance. And so let's go to that now.
The record on case CR 2221-1623, State of Idaho versus Chad Guy Daybell. This is the special sentencing proceeding that has been conducted last couple of days. The jury's been deliberating. The court is advised that the jury has reached a verdict on the special sentencing proceeding and the special verdict form. I'll note the state's present with the 4 prosecutors who have tried the case, Mr. Pryor and his client, Mr. Daybell, present as well. I'll also note there's a courtroom conduct order in effect. I'd appreciate everyone complying with that, as you all have throughout this trial. I will note on the record before we get to the verdict that we did have a jury question yesterday that the court answered, and I've provided the question and copies of the answer to counsel. In addition, a second question came in today. I did go on the record with that question and answer with counsel and the defendant present, returned that response to the jurors. They've now reached a verdict in the case, so the court is going to have the jurors brought in and have the verdict delivered for reading.
All right, let's go. Chad Daybell had no response to the guilty verdict, really. He just kind of sat there as he has this entire time. I was surprised that he didn't present any mitigating evidence. And I saw the lawyer, he's a lawyer that covered this, and he mentioned that possibly Chad might want the highest penalty because it was really strange that he presented no mitigating evidence, none, for why he shouldn't get the harshest penalty. Yeah. Let me fast forward a little because we are a little behind here. I think they stand up when the jury's coming in. Yep, right there.
To review the form.
I agree. It was very surprising that they didn't present any mitigating evidence. None. Pryor talked to the jury about, I don't know. He said some things. Yeah. Hey, Buttercup. Welcome, everybody. Thank y'all for watching this with me. Right after this, I believe the highest on the poll, I put a poll up, and I believe the last time I checked, the highest was covering the Ali Abulaban right after this. I believe that's what came back. Let me fast forward. He's looking at the form.
And it's been properly filled out by the jury foreperson as well as correctly signed and dated. At this time, I am going to request, Madam Clerk, Ms. Holstein, if you would please read the special verdict form. If you'd like to remain seated or standing, it's a long form and will take some time to read, but however is most comfortable for you, Madam Clerk, you may go ahead and read the special verdict form into the record.
In the District Court of the 7th Judicial District of the State of Idaho, in and for the County of Fremont, State of Idaho Plaintiff versus Chad Guy Daybell Defendant, case number CR 22211623, Special Verdict. Part 1. We, the jury, render the following verdict on the alleged statutory aggravating circumstances. 1. Has the jury unanimously found that the state has proven beyond a reasonable doubt the existence of the following aggravating circumstance? The murder of Tylee Ryan was committed for remuneration, or the defendant employed another to commit the murder for remuneration or the promise of remuneration? Yes. 2, has the jury unanimously found that the state has proven beyond a reasonable doubt the existence of the following aggravating circumstance? The murder of Joshua Jackson, hereinafter J.J. Vallow, was committed for remuneration, or the defendant employed another to commit the murder for remuneration or the promise of remuneration? Yes. 3, has the jury unanimously found that the state has proven beyond a reasonable doubt the existence of the following aggravating circumstance? The murder of Tamra, hereinafter Tammy Daybell, was committed for remuneration, or the defendant employed another to commit the murder for remuneration or the promise of remuneration? Yes. 4, has the jury unanimously found that the state has proven beyond a reasonable doubt the existence of the following aggravating circumstance? The murder of Tylee Ryan was especially heinous, atrocious, or cruel, manifesting exceptional depravity? Yes.
Yeah.
5, has the jury unanimously found that the state has proven beyond a reasonable doubt the existence of the following aggravating circumstance? The murder of J.J. Vallow was especially heinous, atrocious, or cruel, manifesting exceptional depravity? Yes. 6, has the jury unanimously found that the state has proven beyond a reasonable doubt the existence of the following aggravating circumstance? The murder of Tammy Daybell was especially heinous, atrocious, or cruel, manifesting exceptional depravity? Yes. 7, has the jury unanimously found that the state has proven beyond a reasonable doubt the existence of the following aggravating circumstance? By the murders or circumstances surrounding their commission, the defendant exhibited utter disregard for human life? Yes. 8, has the jury unanimously found that the state has proven beyond a reasonable doubt the existence of the following aggravating circumstance? The defendant, by his conduct, whether such conduct was before, during, or after the commission of the murders at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society?
Yes.
Yes. If you answered no to each of the above questions, you do not need to answer any other questions. Simply have the presiding juror sign this verdict form and notify the bailiff that you are done. If you answered yes to any of the above questions, then please answer the questions in part 2.
We're going to part 2. Thank
Part
you to
2.
this jury.
We, the jury, render the following verdict on the weighing of all mitigating circumstances against the statutory aggravating
You
circumstances.
presented none.
You are to only answer the following questions for those statutory aggravating circumstances for which you answered yes in part 1. 1, with respect to the statutory aggravating circumstance that the murder of Tylee Ryan was committed for remuneration, or the defendant employed another to commit the murder for remuneration or the promise of remuneration, we unanimously find that when weighed against this aggravating circumstance, all mitigating circumstances are not sufficiently compelling to make imposition of the death penalty unjust. 2, with respect to the statutory aggravating circumstance that the murder of Joshua Jackson, hereinafter J.J. Vallow, was committed for remuneration, or the defendant employed another to commit the murder for remuneration or the promise of remuneration, we unanimously find that when weighed against this aggravating circumstance, all mitigating circumstances are not sufficiently compelling to make imposition of the death penalty unjust. 3, with respect to the statutory aggravating circumstance that the murder of Tamra, hereinafter Tammy Daybell, was committed for remuneration, or the defendant employed another to commit the murder for remuneration or the promise of remuneration, we unanimously find that when weighed against this aggravating circumstance, all mitigating circumstances are not sufficiently compelling to make imposition of the death penalty unjust. 4, with respect to the statutory aggravating circumstance that the murder of Tylee Ryan was especially heinous, atrocious, or cruel, manifesting exceptional depravity, we unanimously find that when weighed against this aggravating circumstance, all mitigating circumstances are not sufficiently compelling to make imposition of the death penalty unjust. 5, with respect to
I think something happened to the mic.
it's back. 5, with respect to the
I believe-
statutory aggravating circumstance that the murder of J.J. Ballo was especially heinous, atrocious, or cruel, manifesting exceptional depravity, we unanimously find that when weighed against this aggravating circumstance, all mitigating circumstances.
Something happened to the mic
We
again.
need a new mic. Okay, we're going to get a separate mic. Thank you.
I think I'm still a little behind. I might be able to fast forward a little to when they get another mic.
Sure.
Yes, start with 5 again. Thank you, Madam Clerk.
5. Okay. With respect to the statutory aggravating circumstance that the murder of J.J. Ballo was especially heinous, atrocious, or cruel, manifesting exceptional depravity, we unanimously find that when weighed against this aggravating circumstance, all mitigating circumstances are not sufficiently compelling to make imposition of the death penalty unjust.
So unjust would mean that he should not get the death penalty. It's my understanding, the way I'm hearing all of this, there is nothing to stop them from imposing the death penalty. So unjust would be if he had a mental defect or if he had some type of, and they literally presented no mitigating circumstances. And I'm so glad I saw the Lawyer You Know's video saying that Chad must want the death penalty because there's no reason. Like the Lawyer You Know was like, I have never heard of somebody not presenting mitigating circumstances in something like this. And so, all right, so let's keep going.
6, with respect to the statutory aggravating circumstance that the murder of Tammy Daybell was especially heinous, atrocious, or cruel, manifesting exceptional depravity, we unanimously find that when weighed against this aggravating circumstance, all mitigating circumstances are not sufficiently compelling to make imposition of the death penalty unjust. 7, with respect to the statutory aggravating circumstance that by the murders or circumstances surrounding their commission, the defendant exhibited utter disregard for human life. We unanimously find that when weighed against this aggravating circumstance, all mitigating circumstances are not sufficiently compelling to make imposition of the death penalty unjust. 8, with respect to the statutory aggravating circumstance that the defendant, by his conduct, whether such conduct was before, during, or after the commission of the murders at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. We unanimously find that when weighed against this aggravating circumstance, all mitigating circumstances are not sufficiently compelling to make imposition of the death penalty unjust. Once you have completed part 2, please have the presiding juror sign this verdict form and notify the bail if you are done. Dated this first day of June 2024 and signed by the presiding juror.
All right. Thank you very much, Madam Clerk, for reading through the verdict form. Ladies and gentlemen, the court will note that given the complexity of this special verdict form, just I think in fairness to all those in attendance, including in particular victims and the parties, the layman's explanation of this verdict is that the jury has made a finding that it would be appropriate to impose the death penalty as it relates to counts 1 through 6 in the amended indictment. And so pursuant to Idaho Code 192515, the court is directed that the defendant would be sentenced to death on those counts. The court will take up a concluding sentencing proceeding. I also have additional counts of insurance fraud. I've discussed with counsel moving forward in a consolidated hearing. The court's proposing that we do that this morning. waiving the right to a pre-sentence investigation report under Criminal Rule 32A. Before I get there, just let me ask at this time.
When he was arrested, he was just like, "Hey, I'm probably going away for a while." Yeah. Like, he was just so flat. I heard somebody else say recently, like, if somebody was digging in my backyard, I would be like, "What are you doing? What's going on?" Like, I would be upset. So we had just a regular tree that died in our backyard, and so, like, a company came and removed it, and they didn't notify us, like, they just came and they got the tree, but it was just a tree. Does that make sense? Like, that was so we didn't have a reaction. It was a tree. It had been dead for a while. Yeah, and we never replaced it. Before we move, we probably will have to replace it because I think for our HOA, I think you're supposed to have a tree out there. He literally had no response, and even to this, he is having no response to the death penalty. And I wonder if his choice living in prison for the rest of his life as a child and wife murderer or the death penalty. I guess if he was found guilty, I wonder if he discussed with his defense lawyer that this is what he wanted. Like, I wonder if that's what he wanted. It kind of makes him, because if he sees himself as a victim, if he sees himself as the one who was deceived, I don't know, like, because to me, he's never admitted, like, yes, I played an active role in this. Yes, I was the one that issued death percentages. Yes, I was somehow involved with Tammy. Like, he's never said any of that. And he's getting to take all of that to his grave. And in the United States, actually carrying out the death penalty takes a long time. His lawyer, it'll be interesting to see if they appeal it at all, because his lawyer is not death penalty certified, but the judge, but like, to me, I think Pryor did a great job defending him as best he could. Like, this was a very difficult case to even try to defend. Pryor's style, I am not a fan of the way that he talks to people. I'm not a fan of that part. But I don't think Pryor, like, besides slipping up and saying murder, like, he did kind of did do that. I covered that in a separate video. That's how I feel. Like, I feel like he's and I think his children that believe him are going to be so distraught and like, "Oh my gosh, the state, this is all." I The people that are on his side, I feel are gonna be even more on his side, and he gets to be this kind of, like, messiah figure almost, which kinda goes with his belief and all of that, but alright. Let's see if they did anything else today.
Of the jurors, is this your true and correct verdict that's been rendered in this case? Very well. Does the state wish to have the jury pulled on the special verdict form?
No, Your Honor. Thank you.
Does the defense wish to have the jury pulled on this special verdict form?
No, thank you, Your Honor.
Very well.
And that's something else that I heard a lawyer say. You normally do just poll the jury just to make sure, like, everybody says, "Yes, this was my verdict." And so I think they've accepted it. Chad's lack of response is chilling for me personally.
As I mentioned, then that's the result of the verdict form. The court would then proceed with additional sentencing on those two counts, as well as the counts 1 through 6 determined now by the jury. Mr. Pryor, is the defense willing to move forward with a consolidated hearing on those counts this morning without a pre-sentence investigation report?
As previously indicated, Judge, yes, we are.
Okay, is the state going to be ready to proceed with a sentencing on those issues as well?
Yes, Your Honor. Thank you.
Okay, thank you. Counsel, I do want to take a brief recess just to briefly prepare for that, given the verdict, and I will come back on the bench. It really won't take long. I would suggest that a 30-minute recess will come back on the record.
So
The
we're
court
gonna
will conclude
come
with
back.
that sentencing hearing. So if everybody could be.
Wow. Wow, wow, wow. Wow, y'all. So I was not expecting this to happen today. Chad Daybell was sentenced to death, to the death penalty, for the murders of Tylee, JJ, and Tammy. And I do want to play Tammy's dad's statement. I thought it was very, um, it was, and I liked what he said about connecting with the other family members, because I feel like the family just wants to connect with Chad's children. And somebody in the comments on one of my other videos on him mentioned, is Chad alienating his children? And I don't know that he's encouraging them to connect with other family members that will be able to support him, or the family members that he might view are against him or don't believe him. I don't know that he's encouraging them to do that. Once again, it's him prioritizing himself, in my opinion, and not prioritizing what's best for his kids. So this is going to be Tammy's father. Tammy's father gives a victim impact statement. And so I'm going to play this right here.
For the record,
Ron Douglas, that's Douglas.
He is off camera. They did not allow these victim impact statements for them to be on camera for this. So he is off camera. Ron Douglas.
Mr. Douglas, which victim in this matter are you related to?
I am Tammy's father.
Have you prepared a statement today?
I have.
Would you please read your statement for the record?
Before moving to Idaho, she lived 1 block away. It was difficult for us when she moved. We'd had daily interactions with her and the children. After they moved, we drove to see them for all of the children's weddings and graduations. Our last visit in Idaho with them was in March of 2020. My wife made me promise to return and visit the kids after she passed away. My wife passed away last June. The tragedy of the case has harmed our family's relationship with the kids.
Yeah.
I will remain open to rebuilding a relationship with them. It makes me angry, and it destroys me to know Tammy was treated how she was. I find it comforting to know that Tammy is resting peacefully in Utah, buried alone, and near her beloved mother.
Thank you, Mr. Douglas.
All right.
So Chad did kind of look away, kind of towards the end of that. My heart breaks for Tammy's family. Tammy's brother also gave a statement as well. And then, and somebody mentioned that Tammy's mom not getting to see the justice, but she also didn't have to see her 2 grandchildren talk about their mom that way. I am still kind of, specifically Emma. Emma was the one that was really, really hard to listen to. It was so hard to hear Emma talk about her mom that way. And so she didn't have to see that part. That could have been really, really heartbreaking. I can't imagine. I don't even know Tammy, and it was painful to hear Emma talk about her mom that way. Garth, you could still tell that he loved his mom, and he was trying to support his dad, I think. And I think that's what the jury thought too. But it was, and so I hope, so Emma's husband, I don't know that I've said this on stream yet. Emma's husband her brother-in-law. So Emma's husband's brother did an interview on Hidden True Crime, and he just talked about how different they are outside of this. Because a lot of people are like, how can Emma be a teacher and all these things? So this is how Emma presented in court. I don't know that's how she is outside of court or how she is as a person. We can't take these snippets and then apply, especially because she so desperately wanted to help her dad. It's almost as though she would do or say anything to help him. And a lot of people are like, well, if she doesn't come out of those beliefs, and because I don't think I don't know that he will ever fully admit what he did. I don't know that he will, but I thought Emma presented different in that interview before she found out about the affair, before she dyed her hair, before she also had contact with Lori. And so I can't. I can't. So I try to stay in the middle when I can. It is hard to stay in the middle for some of this because it is so difficult to see, even as an outsider, somebody that isn't connected to these cases at all. All right. So right now we are going to shift to Ali Abulaban because ooh. So this is a case that I covered. If you know nothing about this case, so Ali Abulaban is so he was discharged from the military. He had a full-time job, but he was also a content creator, a very popular TikTok and YouTuber. And he is a big, so I thought Gregor was like a man baby. Ali is very problematic. I have never seen more characteristic signs of malignant narcissism in my life. And the psychologist came back with a possible diagnosis of bipolar disorder and then some personality disorders. And to me, he presents more ADHD than bipolar. And I would be interested to know if he was on a mood stabilizer or not. I don't I don't think I could be wrong. I don't know that he is because he tried to say he has this chemical imbalance, but he was trying to excuse his behaviors while not doing the bare minimum. So the bare minimum is to admit that your ex-wife can move on and date somebody else. And on the stand, when questioned by the prosecution, Ali Abulaban was like, no, she was mine and nobody else could have her. I'm paraphrasing. That's not exactly what he said, but that was the gist of it. The gist of it was she couldn't be with anybody else. Like she was destroying their family. She provoked him. And that's why he did what he did, despite all of the planning that went into it. So he testified in his trial and it was horrific. I have videos covering it. This is the sentencing of Ali Abulaban. Let's talk about it. He looks super nervous,
In the
and he should
Superior
be.
Court of the State of California in and for the County of San Diego, the people of the State of California, plaintiff versus Ali Nasser Abulaban, defendant, case number SCD 292-181, verdict. We, the jury in the above entitled cause, find the defendant, Ali Nasser Abulaban, guilty of the crime of murder in the first degree.
I don't blame them for cheering. He defamed and just talked so negatively about she was his estranged wife, Anna, and then her friend Ray. So he, within 3 seconds, unalived his wife's friend and her. And to me, he showed no remorse for it. He he just he was just very, very problematic. And those families, because his defense attorney was trying to say that that manslaughter, that voluntary manslaughter, that would have been an appropriate sentence or appropriate verdict because they were considering manslaughter second-degree murder, or first-degree murder. And the jury came back with first-degree murder for the first charge. He has a menacing look. He has a look that is
Silence. Nothing.
Of Rayburn Cardenas Baran in violation of Penal Code Section 187, Parent A, as charged in. Oh, it is. In count 2 of the information, and we further find the allegation that in the commission and attempted commission of the above offense, the defendant Ali Nasser Abulaban intentionally and personally discharged a firearm, to wit, a handgun, and approximately caused great bodily injury and death to a person within the meaning of Penal Code Section 12022.53, Parent D, to be true. Special circumstance as to count 1 and 2, and we further find the allegation against the defendant Ali Nasser Abulaban that he has in this proceeding been convicted of more than one offense of murder in the first or second degree within the meaning of Penal Code Section 190.2, Parent A, Parent 3, to be true, dated May.
I think he was checking with his lawyer to see if that was only the first charge, because they haven't gotten to his wife yet. So he was charged with first-degree murder for Ray.
29th, 2024, jury 4-person. Same title, same cause, verdict. We, the jury in the above entitled cause, find the defendant Ali Nasser Abulaban guilty of the crime of murder in the first degree of Anna Abulaban in violation of Penal Code Section 187, Parent A, as charged in count 1 of the information. And we further find the allegation that in the commission and attempted commission of the above offense, the defendant Ali Nasser Abulaban intentionally and personally discharged a firearm, to wit, a handgun, and approximately caused great bodily injury and death to a person within the meaning of Penal Code Section 12022.53, Parent D, to be true. Special circumstance as to count 1 and 2, and we further find the allegation against the defendant Ali Nasser Abulaban that he has in this proceeding been convicted of more than one offense of murder in the first or second degree within the meaning of Penal Code Section 190.2, Parent A, Parent 3, to be true. Dated May 28th, 2024, jury 4-person. Ladies and gentlemen of the jury, was this and is this your verdict as I have just read to you?
Yes. You decide which to pull the jury.
Yes.
They're going to pull
Ladies and gentlemen of the jury, I will ask you individually, was this and is this your verdict as I have just read? Please answer yes or no to that question. Juror number 1, was this and is this your verdict?
Yes.
Juror number 2, same question.
Yes.
Juror number 3, same question.
Yes.
Juror number 4, same question.
Yes.
Juror number 5, same question.
Yes.
Juror number 6, same question.
Yes.
Juror number 7, same question.
Yes.
Juror number 8, same question.
Yes.
Juror number 9, same question.
Yes.
Juror number 10, same question.
Yes.
Juror number 11, same question.
Yes.
And juror number 12, same question.
Yes.
Your Honor, all answer in the affirmative.
Charlie, report the verdicts. Ladies and gentlemen, you have now completed your jury service on this case. On behalf of the judges of this court, please accept my thanks for your time and effort. Now the case is over, you may choose whether or not to discuss the case and your deliberations with anyone. I will remind you that under California law, you must wait at least 90 days before negotiating or agreeing to accept any payment or information about the case. Let me tell you about some rules the law puts in place for your convenience and protection. The lawyers in this case, the defendant or the representatives, may now talk to you about the case, including your deliberations and work. Those discussions must occur at a reasonable time and place and with your consent. Please immediately report to the court any unreasonable contact made without your consent by the lawyers in this case, the representatives, or the defendant. The lawyer, representative, or defendant who violates these rules or violates the court order may be fined. I would now order that the court's record of personal juror identifying information, including names, address, and telephone numbers, be sealed until further order of this court. If in the future the court is asked to decide whether the information will be released, notice to be sent to any jurors whose information is involved. If they oppose the release of this information, ask that a hearing on the issue be closed.
So I'm letting it continue to play because I guess he begins to cry later. And he also, I got a lot of comments about him hugging his defense lawyers. And I just wanted to talk about that.
Thank you very much.
He's definitely going to appeal it.
All right, Troy, what's his custody status? All right, so the defendant will remain out on no bail. Kind of sentencing date you have?
Council, due course sentencing is June 27th. That is a Thursday. It would be at 9 o'clock.
Would the court prefer to do it on a Friday, or does it have any preference to when we do it?
Whenever you
What date is it? It's a Thursday, Your Honor. June 27th.
So to me, I see anger coming up because so he looked kind of shocked, but his eyes looked big, like, don't let it be like his eyes looked really big. And then I think he's about to start crying. And I just want to see how the emotion comes up for him. And I think he's also aware of the cameras. I think he's aware.
Why don't we do Friday morning?
The 28th? That's fine.
Sir Abulaban, you have a right to be sentenced within the statutory terms. You waive that right, and I will put it over 1 day.
Yes, Your Honor. Yes, Your Honor.
Thank you, Mr.
Probation hearing and sentencing will be on June 28th at 9 o'clock a.m. in Department 2000.
He looks so mad. So that's so June, was it June 28th? Let me go back. Was it June 28th. Okay.
Probation hearing and sentencing will be on June 28th at 9 o'clock a.m. in Department 2002.
All right, we can recess.
And so for me, I do not know what he is going through. For me, the tears right now are for him. And it might be hitting him that he's never going to see his daughter again. His daughter, it's my understanding, is in the custody of his mother. And he's likely going to lose his parental rights at I would think he's going to get life without the possibility of parole. That's what I would think he would definitely get. It's my understanding. So Buttercup, I don't know it for sure. It's my understanding that mom, so his mother, and his mother doesn't live with the father anymore. So it's my understanding that his mother is raising her. Now that all of this is finalized, I don't know if anyone in Anna's family would petition, but that's like those are all the family court things that stay private. This is hard. She is probably going to have a memory of when her dad picked her up from school. They were driving in the car and police surrounded the car, and her dad told her, "Daddy hurt mommy." She is going, because I think she was 5. I think she was 5 at the time. She's likely going to have memories of that. And so I truly hope that the family gets her into some good therapy, that they don't make him out to be some victim and that her mom was this horrible person, because I don't believe that. I just don't believe it. I think her mother loved her very much. I think her mother was in an impossible situation. Impossible. And I'll say it again, the hardest time for individuals in relationships like this is when they choose to leave. that is when it gets the most dangerous for them. And that's why sometimes they have to leave with just the clothes on their back and go to an anonymous shelter. Sometimes they have to change their phone number. Sometimes they have to like go to some extremes to try to get safe. And when you have a child, it does make it a lot more difficult because you do still have to figure out a way to co-parent with with the other individual, and it's very difficult, very hard.
Members of the audience, please wait in the hallway.
And the thing that I'll say for that, because he could have ended himself and her, and he didn't do that. And so I will give him that. He could have, but then I don't know that I don't know. Like he's extremely complex. And also I don't know if he thought he did the perfect thing and he wouldn't get caught. Like that people would understand that anyone in his position would do what he did because he has no insight into his behavior and how he comes off. Zero. Like he has negative insight into just how he comes across, because if he understood how he came across, he would have listened. I believe his attorneys probably told him, I don't recommend that you testify. Like, let us speak for you, let us get these other witnesses, please do not testify. Like, I'm sure his attorneys recommended, because him testifying made it 20 times worse because the jury saw it firsthand. They saw his rage. They saw just how possessive and controlling he was and just how he could like flip on a dime. If he didn't testify, maybe he would have gotten second degree. I don't know. But him testifying to me made things 20 times worse for him. And I think he's upset about them cheering. He's probably upset about the noise that was made. Now, he was incredibly disrespectful this entire trial. Okay? He was incredibly disrespectful of the court. My personal favorite moment, so I have a dark sense of humor. Very, very dark sense of humor. And when he looked at the judge and was like, "Do I have to answer a question? Do I have to answer? Like, what if she asks a question and she wants a specific answer?" Like I covered that one live, and I just couldn't. Like, what if I have to answer questions? So great question. Is there something wrong with me for having empathy for him? No. I don't mind. So he is losing things. I don't so this is a safe space. The only thing I don't tolerate here, I don't tolerate any like evil stuff towards Anna. So I've had to delete some comments about like, well, I don't know, like I've had to delete a few comments about her, but I don't mind. So that's even why I cover these cases, because I try to understand what's going on in someone's mind. But I think his emotion is for himself. And these are just the consequences of his action.
No. You guys take it all back. And then, yeah, that's just the way I operate. So in case anybody says anything, it's like, nope, detective has it. That's
Let's see the hug.
25 years. That way.
Charlie, this is yours, right?
No, none of that's mine.
So all of this, okay.
I think it might be you guys.
The hug might not be in this video, but I do know that at some point they do hug, and okay, like it is, it's to me, his attorneys seem to be shaking their heads during the verdict. So let me like his attorneys seem to be kind of like shake like, oh, like because I think they honestly didn't feel that the state had enough for first degree. I think that's how his defense attorneys felt. With him testifying, for me, it made it 10 times worse, because he said on the stand that he and somebody mentioned this in the comments on my video covering his testimony. On the stand, he said that he took some cocoa so that he could get ready for the confrontation. Which, if I was on the jury, does that mean you were getting ready to go and unalive? Like where I don't think he was getting ready. You don't need grams of cocoa to prepare for a verbal confrontation. You don't need to do that. So, oh, somebody said, so I don't really, because it's like, so if one of my clients went to hug me, so I do side hugs. I personally do side hugs. I don't do like a front hug. I think he needed a hug in that moment. And yeah, so right after the pew pew, he went to his daughter's school and he checked her out of school. And he was saying he was trying to take her somewhere safe for after he was arrested, but he could have been trying to flee the country with her. He could have. We don't know what he was really trying to do. And the state, like, there could have been some more devious plans. We do not know what his ultimate plan was with their daughter. Yes, so it's the church side hug or the hospital side hug. So it's like a so even when little kids come to try to hug me, I'm like, wait a minute. It's like, so I do side hugs. I'm big on personal space. And I don't think I think he thought if she's with somebody, I'm going to handle it. And he saw it was Ray, and Ray to me was kind of handsome. Like Anna might have Anna might have moved on with Ray. I don't know. But and she had every right to do it. She told him that they were done, and he didn't believe her because she had went back a bunch of times before. But like that's what happens in cycles of abuse like that. So Karen is a lawyer in the UK, and she mentions that she will hold her clients' hands at sentencing, and that she will hug them. My boundaries, I have really big boundaries. Like if a client is crying in session, I have like a weighted blanket that I'll go and put on them if they need some comfort. But like I don't. Like it's just I work with people that have had bad experiences with touch, and I'm very careful about what I do and don't do in session. Sadly, there have been some therapists that have went for hugs, but it was the therapist that needed the hug and not the client. That's a red flag. Like, so any touch in session should be initiated by the client, and it should be appropriate. So so the therapist, so like, yeah, yeah. So that's, it's a whole thing. Yeah. Therapists get in trouble for not having good boundaries. And, like I said, I work with cases where people have violated their boundaries in the past, and I just have my own personal bubble is rather large. All right, so I'm still monitoring the Chad Daybell, and they are not back yet. So let's hop over to Chris Gregor. Like that seems to be a nice little segue. So we're going to take a breath. The jury convicted him. They did not convict him of the highest charge, but let's talk about it because they are going to show Brianna, Corey's mother, and I think Brianna and her family, I'm sure they would have wanted first degree, and but they seem, at least he was found guilty of something. And so I'm going to play this one next. I am checking Bell in the background. Okay. So I am checking that one. So Christopher Gregor, if you don't know about this one is sometimes called the treadmill case. Now the treadmill is not necessarily what ended up causing Corey's death. Corey is a 6-year-old boy. He was so adorable, so loving. Like he just seems like he was a really good kid. I am very concerned that the doctors at the hospital that required Corey to come back to do a CPS evaluation, that they notified Chris Gregor that they were going to do that. Because in my opinion, I think he likely was very forceful and likely harmful with Corey the day, because it was the day before Corey was fine, but he had finally told a doctor the truth. And Corey was incredibly scared to even say it. And if it had been my client, I would have never told him. I would have worked it out with the mom of like, hey, let's just say that there is this other situation that we like need to bring him back for a doctor's appointment. Is there a way? Because I'm really concerned. We're thinking he might be the harmful one, because it can happen that the person, if nothing else, they try to talk the child out of telling the truth. And the state never saw the video before when Corey was alive, because there was a lot of back and forth about when the video came out. I saw a podcast with Brianna, and Brianna hadn't even seen the video until right before court. One of her friends testified, and so she hadn't even seen it. She knew about the incident, she knew it was bad, but she didn't see the video until right before court. And so let's go ahead and play the verdict in the Chris Gregor case.
Back on the record, the courts received a note which has been marked Exhibit C 23 in evidence from the jury, quote, "We have reached a verdict," end quote. The procedure is we're going to bring the jurors out and we're going to have the alternates come back in. I'm going to have the foreperson deliver the verdict. Thereafter, I'm going to poll the jury to make sure that each juror agrees that the verdict delivered by the foreperson is that juror's verdict. I understand this is an emotional case. I don't know what the verdict is, but I expect everyone to maintain appropriate courtroom decorum. There should be no outbursts. The jury has to decide the case based upon the evidence. A lot of people have speculated about a lot of things that aren't in evidence, so the jury is required to decide it based upon the evidence submitted in this courtroom. So I'd ask you to please remain calm.
So I did a whole video on that. And Chris, because his mom was going to try to say that he was scared and that because to me, her saying, because I think his mom on the phone told him to not go to Brianna's, because the mom was going to try to say that Chris told her, what did Brianna do? Like, but despite the fact he left before, this is just such a horrific thing. Like, his child is fighting for his life and he's not right there supporting his child through it. I've mentioned before on here, I've had a family member that was on a ventilator. That is one of the most horrific things to see. And I held that family member's hand and I stayed right there with them every step of the way for their recovery. I would have never left the hospital. And the way he leaves is not in like a I'm so upset I left kind of way. It's just like he just walks out. He just strolls out the hospital. And the prosecution's defense was phenomenal. So if you haven't seen the prosecution's closing arguments, it was so strong. And Gregor's parents were there for the prosecution's closing. I felt like they did a great job with this case. It was difficult because there wasn't a murder weapon. We don't know exactly what happened in that apartment, and we don't know if it was, we just don't know. We just don't know. So let's go ahead and play this.
After we're done with that, I give the jury a dismissal instruction, which gives them some indication of what they can talk about, if anything. And then I thank them for their service. At that point, the sheriff's department is going to escort the jurors out of the courthouse to their vehicles. I hope I don't have to say this, but no person can harass, threaten, or intimidate any juror for any reason, especially their service on this case. If that happens, if any jurors are intimidated or have someone come up to them and threaten them or even express some dissatisfaction with them, you're subject to being arrested by the sheriff's department for jury tampering or harassment. And I certainly don't want that to happen. So,
It's so odd that the judge is saying that. Like, I wonder if the judge, I don't know. I've never heard a judge be that forceful about making sure that the jury was okay.
the sheriff's department is prepared to deal with that. There's extra officers on staff all over the county complex to make sure that doesn't happen. So I ask everyone to please respectfully comply with those requirements. Anything from council before we bring the jury up?
No, Judge, thank you.
Where are our alternates?
On their way over.
Okay, so as soon as they get to the foyer, we'll bring out the deliberating jurors. They're in the foyer. 1:15 p.m. jury out.
I think so. I think that's what David Gregor, I think, mouthed "I love you" to Chris. I'm going to fast forward a little.
Have our alternates seated in the jury box to prevent them from appearing on camera. So those are seats 4 and 11. In addition, seats 3 and 13 are empty as those jurors have been excused. Madam Foreperson, would you please rise? Madam Foreperson, has the jury reached a verdict?
It has, sir.
And is that verdict unanimous?
Yes.
Ma'am, I'm going to read to you each count. Please give me the jury's unanimous response. 1, how do you find as to count 1, endangering the welfare of a child?
Guilty.
2, how do you find as to count 2, murder?
Not guilty.
3, how do you find as to the charge of aggravated manslaughter?
Guilty.
And you did not answer question 4.
So he was found guilty of aggravated manslaughter. And so that is Brianna, Corey's mom. And Brianna's dad went on a news station and gave an interview that's available on YouTube. He basically just said that like they were glad that he was found guilty of something, and that they continue to, the next fight is going to be for the state, that there were major balls dropped with the state. And the family thinks, because of the Gregor's reputation in the town, that their complaints were looked at on deaf ears because of connections that the family has. That's how Brianna's family feels. So
4. At this time, thank you, Madam Foreperson, you can be seated. At this time, I'm going to poll the jury. Members of the jury, you've heard the verdict as read by your foreperson.
And the shaking the head, I just don't know if that's him not wanting to go to jail for what he did. And his defense attorney also gave an interview. If you want to check that out, that's available as well. And the defense attorney was pretty sure that they were going to come back with guilty for the treadmill video for the first count. And they were, of course, hoping for a not guilty for the second count. But he was found guilty of aggravated manslaughter.
At this point, I'm going to ask each juror by number, except the 2 alternates, to respond yes.
And so that's how that part ends. Let me know if y'all have any questions. Let's see. All right. So Sarah, yeah, him shaking his head, Chris Gregor, I think he disagrees with them finding him guilty. He did something. Something happened. His son was 100% okay. He never, because I think he might have pled not guilty to the first count, to the child abuse count. I don't think he pled guilty to that. And so I don't know. It's a very, very difficult case. Very difficult. So the judge is back in the Chad Daybell case. Let's go on ahead. So this is I'm a little behind. Okay, I think they're going to bring the jury back. Okay, so let's see what's happening here.
Continuing the special sentencing proceeding the jury has returned its special verdict. The court would note that pursuant to Idaho Code 18-4004, which is the punishment for murder statute in Idaho, that crime.
So for anyone that missed the first part, so today the jury deliberated on a Saturday. The jury deliberated this morning and they came back with a verdict they finished their deliberation because it was towards the beginning of the stream. So I think that was read about 1:15 p.m. Eastern. And now they and the jury came back with finding that Chad should get the death penalty, that there were no mitigating factors for them to not impose the harshest penalty. But prior presented zero evidence of any possible mitigating factors. And I don't know if that's because Chad didn't want to say that he had some religious belief or that he had some mental delusion, or it seems like he didn't present any mitigating factors. It seems like Chad didn't want to do it. And so I don't know. Sonny, for which trial? I've covered too many. So for which trial? I'm not sure. And throughout this entire process, Chad shows no emotion. And there's a difference between acceptance and then just I don't even know what to call this, because he's just, I don't know. Because so Lori seemed upset to be judged, because Lori said God is the only one that can judge me. And Lori seemed to kind of be upset that she was found guilty. And she was like, the children are happy and Tammy is happy. And I visit, Lori went off on her tangent. He just seems to be like, yeah. I think on death row, I think you get your own cell. Some people, I don't know, this is just, it's really hard to try to wrap your mind around it because it's just so odd.
In murder of the first degree can be punished by death. And under Idaho Code 19-2515 subsection 7A, that states that if the jury finds that a statutory aggravating circumstance exists and no mitigating circumstances exist, which would make the imposition of the death penalty unjust, the defendant will be sentenced to death by the court. The court's reviewed the findings of the jurors in the special verdict form. They've taken their time through these deliberations to return that verdict. And so the court will proceed with sentencing first on counts 1 through 6. And again, this is an unusual hearing because.
So, and Karen, I agree with you. And Dr. G talks about how Chad lifts his nose up. I'm above this. I'm above you. This is a superior stance versus a more inferior. He has this superior stance. He his nose stays up. That's what Dr. G explains.
The sentencing hearing's already been taking place. We've heard from the victims through impact statements and arguments from counsel. That's already taken place. In addition, a pre-sentence investigation report is not to be ordered in these hearings, so the court does not reference that. The court then orders as follows, and this will be contained in the court's judgment. At the conclusion of the case, as to count 1, the conspiracy to commit first-degree murder and grand theft by deception for the murder of Tylee Ryan, upon the jury's finding of guilty and the return of the special verdict form, the jury finding beyond a reasonable doubt and having returned the special verdict that the aggravating circumstances when weighed against the mitigating circumstances do not make the imposition of the death penalty unjust. The court, therefore, on count 1, the defendant is sentenced to death.
Just no response, nothing.
On count two, the first-degree murder of Tylee Ryan, the jury finding beyond a reasonable doubt and having returned the special verdict that the aggravating circumstances, when weighed against the mitigating circumstances, do not make the imposition of the death penalty unjust. The court therefore, on count two, sentences the defendant to death. On count three, the conspiracy to commit.
And that's something else that Dr. G explains, talks about too. He is incredibly controlled, because even if something is happening over here, he just looks like he doesn't, nor like other people kind of look over. And my chair is making weird noises. My chair is hitting. I have something back here. If it comes through the mic, like if he has to look over here, he looks like this. He doesn't even turn his head. Like he just sits there. And I mentioned earlier in the stream that I wondered if he did have this martyr complex, this God complex, if he feels like if, because Lori said it out loud and he's just quietly saying, okay, they crucified, gee, they're gonna those aren't the same circumstances. That's not the same situation. He was aware possibly something happened to those children. And I saw on another stream, they talked about just how emotional the gallery and the jury was when they were breaking down just what happened to Tylee. And it was very powerful hearing everybody that just loved them talk about them and give those impact statements. All right, let's keep going.
First-degree murder and grand theft by deception for the murder of J.J. Vallow. The jury finding beyond a reasonable doubt and having returned the special verdict that the aggravating circumstances, when weighed against the mitigating circumstances, do not make the imposition of the death penalty unjust. The court therefore, on count three, sentences the defendant to death. On count four, first-degree murder of J.J. Vallow, the jury finding beyond a reasonable doubt and having returned the special verdict that the aggravating circumstances, when weighed against the mitigating circumstances, do not make the imposition of the death penalty unjust. The court therefore, on count four, sentences the defendant to death. On count five, conspiracy to commit first-degree murder of Tammy Daybell, the jury having found beyond a reasonable doubt and having returned the special verdict that the aggravating circumstances, when weighed against the mitigating circumstances, do not make the imposition of the death penalty unjust. The court therefore, on count five, sentences the defendant to death. On count six, the first-degree murder charge, the murder of Tammy Daybell, the jury having found beyond a reasonable doubt and returned the special verdict that the aggravating circumstances, when weighed against the mitigating circumstances, do not make the imposition of the death penalty unjust. The court therefore, on count six, sentences the defendant to death. The court's next going to take up counts 7 and 9 on the insurance fraud counts. Before I do that, from the state, are there any questions regarding the court's judgment as it relates to counts 1 through 6?
No, Your Honor. Thank you.
Questions from the defense?
No, Your Honor. Thank you.
All right, moving on to insurance fraud, then the court will note that I am required to go through a sentencing proceeding on this. These are separate counts that have not been determined in the special verdict form by the jurors. Some brief procedural history. Mr. Daybell was charged by amended indictment with counts 7 and 9 insurance fraud under Idaho Code 41293, which is a felony. Mr. Daybell pled not guilty to those counts on June 9th, 2021. Thereafter, this trial was held, and as part of the findings of the jury in their verdict, they did find the defendant guilty of both of those counts. The court has considered, in lieu of a pre-sentence investigation report, the information that I've heard throughout this trial. I also heard information regarding these charges in the previous trial held last year against co-defendant Lori Vallow. I've also heard information received during the special sentencing proceeding relating to those counts as well, and have considered that information in lieu of a pre-sentence investigation report. And I'll also note the defendant waived the pre-sentence.
Just in case the death penalty charges were ever overturned on appeal or anything like that, because maybe something happened, because maybe there is a reason to appeal this for some reason. He already has the charges related to those other offenses. So they're just going, he has to get sentenced for everything. And because there are often appeals that people have when they are sentenced to with the death penalty, because we don't want to for truly innocent people to, so like there are typically a certain number of appeals. People can waive those appeals, but there is a process. People can ask for, what's the word, for their sentence to be commuted, I think, or something. Like they can ask the governor for like to not be put to death. But so I think that's why they still have to just give a sentence for all of the charges.
This investigation report, and is permitted to do that, and the
I'm not a
court can
lawyer.
allow that under Criminal Rule 32A. At this time then, before I move forward with the sentencing on counts 7 and 9, I will inquire of the state, is the state wishing to make any sentencing recommendation as it relates to count 7 or 9?
And Your Honor, just for clarification, were the insurance frauds count 8 and 9?
As listed in the amended indictment, they are listed as counts 7 and count 9.
Thank you. Co-counsel just clarified for me on that. Your Honor, the state is prepared to make a statement. First, I would indicate for the record that in relation to the sentencing hearing, the sentencing portion handled yesterday, the state did make our best attempts to reach out to all statutory victims to allow them the opportunity to be heard by the court. And those that the court heard from yesterday were the ones that had wished to make impact statements. While not directly related to the insurance fraud, I did just want to make a clear record of that. In relation to the insurance fraud charges, in light of the sentence that has been imposed by this court and by the recommendation of the jury in relation to the other charges, the state would indicate we think that the victim statements covered everything the state could say. While the insurance charges again are attenuated to it, we've lost 3 individuals that the state can do nothing to bring them back. And so the best we can do is move forward in seeking justice on their behalves. In relation to the insurance counts themselves, given the sentences, we would recommend this court impose jail time and have that, or prison time, impose a sentence and run it concurrent with the imposition of the other sentence by this court. I believe they carry up to 15 years in prison. We'd recommend they run concurrent with each other and with the imposition of death in this case. We would also recommend restitution in the amount of $130,000 to LifeMap and $300,000 to Primerica. As part of that, we would also recommend a waiver of any fines or court costs in this matter in order to allow restitution to be paid if any money is available to go towards that.
All right, thank you for the state's sentencing recommendations. Mr. Pryor, does the defense wish to make sentencing recommendations as to, I'll do them collectively, counts 7 and 9, the insurance fraud counts?
No, Judge, there's nothing further. Thank you, Your Honor.
All right, is there any objection to the requested restitution amounts of $130,000 and $300,000?
Judge, we may need to set that out at this point, but I'll let the court know if that changes.
All right, I'll permit 30 days for the scheduling of a contested hearing on restitution. If that becomes an issue, we could conduct that hearing most likely remotely on a Zoom hearing if it becomes an issue. At this time, I will ask, because I need to on these counts. Before I impose any sentence, Mr. Daybell, you do have the right of allocution, which permits you to make a statement on your own behalf in any mitigation of these offenses. Is there any statement you would like to make before I proceed with sentencing on those counts?
No.
Very well. The court then, having considered the information previously referenced, finds that pursuant to Idaho Code 41293, which under subsection 4 indicates a penalty of up to 15 years of prison on each of those two counts.
Welcome, Kelly. You missed all the things. So this is the live Chad Daybell. I'm about maybe like 10, maybe 5-10 minutes behind, but Chad Daybell has been sentenced to death. So I guess 3, I can't count, but like he's been sentenced to death, and he's currently being sentenced for the fraud charges.
Court is going to impose a prison sentence of 15 years. So a 15-year sentence will be imposed on count 7. The court will take under advisement the issue of restitution requested by the state. The court will not impose any fines. The court also will impose a 15-year prison sentence on count 9. Also pursuant to the same statute, take under advisement the issue of restitution. The court will note in imposing these prison sentences that I have reviewed Idaho Code 192521, which requires me to go through certain criteria about the imposition of a prison sentence versus a possibility of parole or a lesser sentence. And I would note that the rationale for the prison sentences is that these are intertwined with the murder charges for which the death penalty has been imposed on those counts. And when the court looks at the sentencing factors under 1925-21, I would note in mitigation that Mr. Daybell has been incarcerated an extensively long time in local jail and has a previous law-abiding history, and I have considered that. I've also considered that he's always conducted himself respectfully, from what I've heard from all of the jailers that have ever interacted with him over the years that he's been incarcerated for these charges. However, the court finds under Idaho Code 2521 also that any lesser sentence would depreciate the seriousness of these offenses because this life insurance was obtained based on the murders of individuals and procuring life insurance payouts unlawfully. And because of that, it's the most serious offense, that circumstance that could lead to that. In addition, imprisonment will provide an appropriate punishment and deterrent for the defendant and others, and will also be a deterrent for the community as well. So the court having then concluded with the sentencing on that, I will not order any fines because the defendant's previously been deemed indigent and has received the death penalty on these murder counts, and find it would be futile to have an order of fines in the case.
Okay.
So with those remarks, then the court typically would address the defendant further, but in the special sentencing proceeding, the victim impact statements and the evidence has already demonstrated on the record, I think, the seriousness of what's occurred. And I don't find any reason to further delve into the court's rationale other than what was listed in the statute. So unless there's anything further, that will conclude the sentencing, but I will address the post-conviction issues that need to be addressed at this time. Does the state have anything further then on the sentence and count 7 and count 9?
No, Your Honor. Thank you.
Anything further from the defense?
No, Your Honor. Thank you.
Okay. Mr. Daybell.
The way I kind of see it, it's almost like Chad wanted to try to get his side in front of the jury. And if the jury found him guilty, that he wasn't going to fight after that. Yes, Langston?
Can I do the iPad?
Yes. Dogman? All right. Stay on that side. Good job. Just give me 1 second while I parent. Here you go. So here's, there you go. All right. And then you just scroll. Yeah, like that. All right. Thank y'all for letting me parent for a second. His father is here. He's in the basement, but mommy has the devices. So he found a new book series that he loves, and so he's been reading those books. Can you close my door, please, Langston? All right, so let's go on ahead and keep going here.
Well, in this case, given the sentence that was imposed in counts 1 through 6, there's a special appellate and post-conviction procedure for capital cases, and an automatic stay may be in effect. There's a statute that's Idaho Code 192719 that sets out certain deadlines. I am providing you and counsel with a courtesy copy of that statute, but I will note a few of the deadlines that are listed in there. Under subsection 1, when the punishment of death is imposed, the time for filing an appeal shall begin to run when the death warrant is filed. Number 2, the death warrant shall not be filed until 42 days after the judgment imposing the death sentence has been filed. Number 3, within 42 days of the filing of the judgment imposing the punishment of death, the defendant must file any legal or factual challenges to the sentence of conviction. There's other important and critical deadlines that are contained within that statute, and I am going to provide a copy of that to Mr. Pryor to ensure that the defense is well advised of those post-conviction rights that would apply in this special proceeding. I'll also note that there's an additional rule, Idaho criminal rule. If you'll give me a moment, I think it's 44.2.
So normally the psychological evaluations happen for the pre-sentencing portion, or if the defense was going to take a mental health stance, they would request a psychological. The fact that the defense presented no mitigating evidence, none. So IQ can be a mitigating factor. Intellectual ability, so IQ can be a potential, and I think Chad's IQ is likely average. So I'm not saying that he has a low IQ, but you would normally present some type of mitigating circumstances or factors. They didn't do a pre-sentencing report. And so I don't know that he's met with a psychologist. Now he can receive therapy I don't know that he would be open to therapy, but he can receive like therapy while he's in jail. And unless he's using a mental health defense, those services remain confidential. But if he was saying I'm psychotic, or like if he's making a mental health defense, then those records can come into the trial. But that's my understanding. I do not believe he's had a psych eval. Just because they literally presented no evidence. And I think Chad didn't want to look crazy because Lori, like that was Lori's thing. Like not what I'm like, and maybe he doesn't want to be labeled delusional because Lori was diagnosed with religious delusions. And she avoided the death penalty because there was some evidence that came in late. And so
Criminal Rule 44.2.
and so the state had to drop the death penalty because of the like an evidentiary rule. So that's how she avoided the death penalty being an option for her, because she didn't waive her right to a speedy trial. She wanted to proceed as soon as possible. Chad waived his right to a speedy trial, and he was able to face the death penalty.
And that's the mandatory appointment of counsel for post-conviction review after imposition of the death penalty. That rule is also applicable in your case, and a copy of the rule itself is going to be provided to you in counsel to ensure that you're well aware of any post-conviction rights you may have. With that, then, the court is going to conclude the special sentencing proceeding. Is there anything further I need to take up from the state?
No, Your Honor. Thank you.
Anything further from the defense?
No, Your Honor. Thank you.
Okay,
Wow. 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 So there was a great question, and I have to give the lawyer credit, because somebody asked, why do I think he didn't put on any mitigating evidence? And the lawyer, Peter, he said the only reason why somebody would do that is if they wanted the death penalty or they weren't going to fight it. Like that's the only reason why you wouldn't put up mitigating evidence. Every sentencing I've ever watched, they have presented some mitigating evidence, and they presented none. None. They tried to make Chad the victim because they tried to say Chad was going to be Lori's 5th victim. But the jury didn't buy any of that. The jury didn't buy it at all. And so, wow. All right. So I want to switch to our final case for today. Let me know if y'all have questions. Today we have covered, Gregor. We covered Abulaban, Daybell, and now for Troconis. Michelle Troconis was found guilty of conspiracy to commit murder, and then also some other charges related to the death and disappearance of Jennifer Dulos. And the victim impact statements, I covered those in a different video. I am not going to cover the people that spoke for Michelle. I am going to let us watch Michelle's statement. It's just, this is how you try to get sympathy from the judge. Chad did not do this. And so, but the judge, some people were mad with the sentence. The state asked for 45 years. Jennifer Dulos was 50 years old, and one of the children, or somebody, asked for 50 years as well. She was facing up to 45 years. The judge is not going to go that high. And I think this judge really goes with the law, and he just really tries to stay neutral in all of this. I think Michelle's family wanted her to get off altogether. Michelle's family was like, this is all Fotis's fault. So Fotis is Michelle's ex-boyfriend, Jennifer Dulos's husband at the time, but they were estranged. Michelle and Fotis started an affair before and when Jennifer found out about the affair, she left him. And it just came off like Michelle wanted Jennifer's life. That's just my thought. I do not know that for sure. And Michelle is going to deny that. She's going to be like, no, I wasn't jealous of their life. Her daughter, I think, is 19 years old, and she gave a statement as well. I like the judge. Some people were mad. Some people were really mad. I was okay with it. I was okay. I hate when the judge is too nice, because I feel like in the Timothy Ferreter case, I feel like the judge sympathized with the defendant and went lighter on him because he felt sorry for him in some way. It was because he downward departed. He gave less than what the statutes, what everything required or would say. And so, yes. All right. So let's go on ahead. So prepare yourself. Michelle is going to give her statement. It's going to be emotional, and we'll talk about it.
Your Honor, I am deeply saddened by this tragedy that has affected so many lives.
The fact that she looked back at the victims. So there are 5 children that are without their mother. 5. Jennifer Dulos had 2 sets of twins and then like one single birth. So she had 2 sets of twins and one single birth. 5 children altogether. And their statements, every single one of Jennifer's children got up there and gave powerful statements, each one more powerful than the next. The nanny, all the families that absolutely loved her, they all spoke for her. Michelle's family did come because her daughter also gave a statement about, not wanting to be without her mother as well. Like there were lots of people got up and gave statements. And now Michelle is giving her statement.
Found out things before and during trial about a man, Fotis Dulo. I thought I knew and loved. I deeply regret ever being in a relationship with Fotis Dulo and bringing my daughter, my family, and myself into our lives, into his life. I am a person of profound faith, and I have been praying and will continue to pray for those who suffered and still suffer. I am thankful to my whole family and my dear friends who have stood by me and support me. I am grateful to you, Your Honor, to let me express myself. Thank you.
Thank you.
That concludes our presentation.
Thank you. What the court is going to do is take a recess and
So we are watching it behind schedule, so we can skip the recess to the judge's remarks. And the judge is going to talk about his stance with the court and with this statement. And I think she was sorry that Jennifer was gone. I don't think she apologized for like her role or for having helped and having lied. She lied. She gave Fotis an alibi, and she was part of the reason why he was free for 9 months after Jennifer disappeared and they were trying to make it seem like she just ran off and she had some mental health condition and she just ran away from her family. That's what they tried to make it seem like Jennifer did, and she would have never. She did not. And I guess during the trial, Michelle had a laptop open, and for the news to see, she opened a document that I guess had some mental health diagnosis or something. And I believe the judge is going to comment on some of her behavior during court. So let's go ahead and get into the sentencing.
remarks from family members. The remarks from what the court would consider victims of the crime. Almost always there is no single appropriate sentence. Otherwise, the legislature would have designated a single appropriate sentence for every offense. The charges here are conspiracy to commit murder, which is a Class B.
So I'm just going to speed him up just a little. He's a lovely guy. I'm going to speed him up to 1.25. If it's too fast, I will slow it back down. And then there's a good question. So y'all know I'm a very liberal Christian, but is it meaningful to hear the defendant say she's a person of faith, and that she prays for the victims? So in my opinion, in my personal opinion, she is saying this now to get sympathy from the judge. She has showed no emotion or any sympathy for these victims until she was found guilty, in my opinion. In my opinion, she showed no remorse, no care for Jennifer. And I think she was upset that people saw how she really was, because one of the children got up and talked about lying to her mom for her dad and Michelle. If I said Jennifer, because sometimes I get my names mixed up. So the defendant is Michelle. Like one of the children talked about lying about Michelle being at visits to Jennifer, their mom, and just how like the children's statements, like this wasn't because they couldn't get justice from their dad. So Fotis Doulos, he unalived himself after it was looking like he was going to be arrested. Like he had been charged with the crime and he was facing those charges to avoid all of this. And I think in his letter, he blamed he blamed being charged. I don't know. Like he proclaimed his innocence. Like he's a messy person. Okay. But he did that. And in his letter, it's my understanding that he he couldn't handle being charged with what he had been charged with, despite the fact that he did it. Like there's tons of evidence that he did it. He is on video discarding Jennifer's bloody items all across Hartford, Connecticut. Like he did it. And but she was convicted of conspiracy to commit murder. So let's hear this at 1.25. Let's see how this goes.
Felony. The legislature has set the sentencing range, not less than 1 year, nor more than 20 years. Which means the legislature contemplated, in some instances, sentences of no more than a year, and in the same instance, sentences of 20 years. The legislature has given the judiciary a range. Conspiracy to tamper with physical evidence is a Class D felony, maximum 5 years. Tampering with physical evidence, a Class D felony, maximum 5 years. Hindering prosecution is a Class C felony, not less than 1 year nor more than 10 years. The court relies on what the law states and what the law allows to be proper consideration, setting a sentence. The court relies on the nature and circumstances of the offense, the history and background and character of the offender. After such consideration, the court turns to what are called the traditional purposes of sentencing: specific deterrence, general deterrence, punishment, incapacitation, rehabilitation, vocational or educational training, and medical treatment. Those factors are not all given equal weight depending on the nature and circumstances of the offense and the history, background, and character of the offender. The court does not take sides. If the court knew possibly any one of you had a bond with any one of you, this court would not have tried that case. It's not the court's role to side or favor one side or another. Sentencing, in many ways, is a dispassionate exercise. The court has no bond with any individual who spoke today or any other individual involved in the case. The court cannot develop the passions that one side or the other has. In State versus Huey, that's 199 Connecticut, 121 and 126, a 1986 case, the Connecticut Supreme Court held that the sentencing court may consider information that would be inadmissible at trial for the purpose of sentencing. That same court held that evidence of crimes for which the defendant was indicted but neither tried nor convicted may be considered. Well, the word indicted and the process of indictment is not generally employed in Connecticut. Essentially, that means where there has been a finding of probable cause, but there has been no trial or no conviction. Additionally, as a matter of due process, the court may consider information that has a minimum indicia of reliability. Now, that minimum indicia of reliability is not limited to unfavorable information. The court can consider favorable information that has a minimum indicia of reliability. The court certainly considers the victim impact statements. Every victim has the right to be heard before the court sentences a defendant. That's part of the Connecticut Victims Bill of Rights, which is read every day in every courthouse here in Connecticut. The court would clarify what it perceives as perhaps a misconception of what the court's role is. The court does not deliberate with the jury. The court does not deliberate on the evidence at all. The court hears the evidence as the evidence comes into the record. So when you hear that the court has a view of the evidence, the court has no view of the evidence. What the court has is a verdict and what could have been the reasonable and logical inferences from the evidence that was adduced. The court would not know what the jury discussed over those many hours. What the court can find is this. It was clear during the jury instructions that the court instructed the jury that it may draw any reasonable and logical inferences from the facts found to have been proven. Based on the verdict, the jury could have found the following reasonable and logical inferences. Fotis Doulos was not home at 4 Jefferson Crossing the morning of May 24th when his wife was murdered, but the defendant said he was home. When the defendant
This judge is going to break down the evidence and make it very clear that the court is not being harsh to Michelle because they can't sentence Fotis Doulos. Like that's not what's happening here. She did things and she is now being held accountable for the things she did. He makes that very clear.
admitted that he was not home, the defendant, who had been angry about Doulos's talking to other women, did not even ask him where he had been. The defendant, who was angry that he had visited his wife, did not ask him if he had visited her. In fact, the defendant, as the court remembers the evidence, didn't ask him anything. The jury could draw a reasonable and logical inference that the defendant knew where he was and knew what he was doing.
Exactly.
The defendant said she saw Kent Mawhinney and Fotis Doulos together in the office at 4 Jefferson Crossing on the morning of May 24th, but the defendant did not see Fotis Doulos and Kent Mawhinney in the office at 4 Jefferson Crossing on the morning of May 24th. There was a phone call made to Doulos's phone, which Doulos left intentionally at 4 Jefferson Crossing. The defendant answered it, and the jury could draw a reasonable and logical inference from all of the evidence that the defendant answered the phone to make it appear that Doulos took the call himself on the morning of May 24th at 4 Jefferson Crossing, when he was really on his way to or in New Canaan. When a police officer came to Fort Jefferson Crossing soon after the murder, the defendant did not even go to the door, even though her daughter, who was not home, may have been the subject of that conversation at the door. Now, it has been clear that the defendant cares deeply for her daughter. The jury could draw a reasonable and logical inference that the defendant did not go to the door because the defendant knew the reason the officer was there, to find out more about the disappearance of Jennifer Doolittle. These are reasonable and logical inferences from the facts that were adduced in the case during the trial. The defendant traveled through a part of Hartford with Doulos as he dumps the bloody clothing of his wife. The jury could draw a reasonable and logical inference that on the same day, the defendant helped him pretend he was home in the morning, but in the evening accompanied him to get rid of the evidence. The defendant's DNA profile was found on one of the bags disposed of in Hartford. The jury could draw a reasonable and logical inference that the defendant helped dispose of the evidence knowingly. The jury could draw a reasonable and logical inference that the defendant helped Fotis Doulos clean up traces of evidence at 80 Mountain Spring Road because the defendant and Doulos were there together cleaning on the same day that the Tacoma traveled to New Canaan. This is a flurry of irregular activity all on the same day. The jury could draw a reasonable and logical inference that the activities of that day were so irregular that the defendant could not possibly forget them in the span of 2 weeks.
I forget if he brought up the dumb girlfriend, because she tries to play like she doesn't understand, because even the use of interpreter, the kids said, one of the kids, and Sarah probably remembers exactly which one it was, but one of the kids was, I'm going to speak to you in English the way I've always talked to you, or something like that. Like she understands English fluently, but like she's trying, I don't know if she wanted the jury to think that she couldn't fully understand what was going on, or I don't know, but she does have an interpreter. English isn't her first language, and this has happened in a few other cases that that I've covered as well, where they have had an interpreter, and it's the defendant's right to be able to be provided an interpreter in the language that they're most comfortable with. And so yes, all right.
Even if the jurors individually had doubts about the defendant's guilt, each one of them ultimately concluded that their doubts were not reasonable. This is not a view of the court's view of the evidence. These are logical and reasonable inferences that the jury could have drawn. The court is going to talk a little about the philosophy of sentencing. Sentencing is not the product of the court's passions or prejudices. The court doesn't have a bond with anyone involved in the case. It's a dispassionate exercise. The court did not investigate the case. The court did not talk to the victims. The court has no conversation with the defendant or the defendant's family. So there are some questions that are age-old. Does the court, the sentencing court, adopt the public opprobrium, the indignation of the community?
Okay. Okay.
When does retribution turn into revenge?
Wow. 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 So this, sorry, we have this one. So this is Michelle Troconis, And she was charged with conspiracy to commit murder. She was found guilty of conspiracy to commit murder in the death of Jennifer Dulos. So that is the current case that we are doing now. There was a lot of public outcry about this, and Jennifer's body still has not been recovered. And I said it in a comment, and I wanted to say it on stream because somebody was like, it might be better for the family to not know exactly what. No, or for the family to not have her. Like somebody made a comment, and it was I think it was made in good faith, because I delete the comments that I think are not in good faith. Having whatever you can have of your loved one to put them to rest, to know that they're not alone, that they're not just discarded somewhere, to be able to put them to rest often helps give the victims of a violent crime. They will never have complete peace. This is some of the hardest and most complex grief to kind of cope with. And these kids have the additional grief that it was their father, their stepmom, or stepmom or dad's girlfriend that did this to their mother. Like, the kids have this additional kind of trauma. And then to not even have her resting place, to not have a place that you can visit, or to not have ashes, to not be able to have her, that makes it hard to grieve. It reminds me of the Harmony Montgomery case, and how that court system, those officers, they have said, we are never going to stop looking for Harmony. You want, even if my loved one, even if it was a horrific way, even if all that's left is bones, I would want to be able to put them to rest. And so I do think it is important. And I think that's what adds an additional kind of emotional pull in this case, because so many people really feel like Michelle knows something about where Jennifer is. We don't know that for sure. We just kind of feel that way. And but the judge is staying neutral, and that's really how we want the courts to work. Like, you don't want the court to have this emotional response, either in a positive or negative way. So in a way that is for the prosecution, or in a way that's for the defense. Like, you don't want it to have that type of response. And so that's why I really do respect this judge. And I am glad. There was a part of me that wondered, because he had houses that he did construction on. So there was a part of me that wondered if she was on some site, some construction site, similar to how Chad and Lori were trying to put like a trailer out on the house in the area where the children were buried. There was a part of me that wondered if, because he had properties, and so there was a part of me that wondered if something could be like that. I have no knowledge. I don't know that for sure. That's just a thought that came to mind. All right, let's keep going.
What's the role of empathy? Should the court exercise sympathy for one side or another? These are age-old questions. The court relies on what the law says. The court can consider the nature and circumstances of the offense, the history, background, and character of the offender. Every exercise is not an either-or exercise. Often, the good and the bad are true.
That's a good point. So, because all these people came up and gave these glowing statements about Michelle, and then Jennifer's side gave horrific statements about Michelle, and he's saying both sides are probably are telling their truth, and it's his job to just do what the law says.
What is the purpose of the court taking into consideration the victim impact statements? Is that only for the purpose of sympathy? The court uses the victim impact statements to assign, in its view, the proper weight to any one of those traditional purposes of sentencing. Sentencing is not arbitrary or capricious. It's not a matter of how the judge feels that day. Court wants to also address what has become, over the course of perhaps centuries, perhaps not, a cliche. Michelle Troconis' life is in your hands. Michelle Troconis' life is in her own hands. What Michelle Troconis decides to do today, tomorrow, and the next day is up to her. From what the court has heard, she has a great deal to offer. Court has no control over what her decisions will be. Her life is hers. The following sentences are going to run concurrently. On the count charging conspiracy to commit murder, 20 years execution suspended after 14 and a half years to serve, 5 years probation. Tampering with physical evidence, 5 years execution suspended after 4 years.
So I'm going to slow this part down. Kelly, you might be using a word that's banned on YouTube. So, and I don't set that. So sometimes if you use certain words in chat, YouTube will automatically filter out certain words. So Kelly, I saw that most recent post. I'm not sure. I don't think I see any of the other ones. So you might be trying to use a word that YouTube doesn't like.
5 years probation. Conspiracy to tamper with physical evidence, 5 years execution suspended after 4 years, 5 years probation. The second count of tampering with physical evidence, 5 years execution suspended after 4 years, 5 years probation. Hindering prosecution, 5 years execution suspended after 4 years probation. After 4 years, rather, 5 years probation. Total effective sentence, 20 years, execution suspended after 14 and 1/2 years, 5 years probation.
And I think there was some confusion. So it's my understanding, y'all correct me in the chat if I'm wrong. So she was sentenced to 20 years and she has to serve 14 and a half of those. That's my understanding of what she was sentenced to. I think some people thought that he suspended for, I don't know. Like I think there was some confusion because the way it's worded, I think is consistent with Connecticut, but I hadn't heard it said this way. So it's my understanding that she has to serve 14 years before she's eligible for probation. That's my understanding. Correct me in the chat if I'm wrong. Not a lawyer. I am not a lawyer. Okay.
You will have an opportunity to challenge every finding that the jury made and every ruling that the court made. Madam Clerk, you can give the defendant a notice of right to appeal.
Her attorney is going to ask for her to not have to be like for her to be out on bond, and the judge is going to say no, that's not like a constitution. Like no, she's going to be remanded, and because they wanted her to be out on bond while she's doing her appeal. And I do have empathy for Michelle's daughter. Michelle's daughter does, and the hard part is that my heart breaks for Jennifer's children as well, who can't even visit with their mom, who have completely lost their mom. And so I am going to play because Michelle is going to look back at the end, likely to her daughter and her family. She's going to get more upset as she walks out. And I don't think there's sound right here, which is fine. Yeah, right there. All right. So that's what happened. That is what the jury decided and found. There was a really great question that I saw earlier. So, as a therapist, what do you think about the use of reasonable person standard? And so each jury gets to decide that. The interesting thing was when Ali Abulaban said, like, anybody would do this. When he said, like, if you walk in and you see this, anybody would react the way I did. And it's like, oh, no, sir. No, no, no. Like, if I walked in and my husband was talking to somebody on the couch, even if they were cuddled kind of close, I would have some questions. I would have some questions for my husband. I would have some questions for my husband. And things would kind of go from there. I would never escalate it to the point he did. Because I just don't, but don't do crimes. People like it when I say that. I think I got that from Emily D. Baker. I'm pretty sure all the law tubers say don't do crimes. I'm on the psychology side. I love explaining the psychological aspects of these things. And so that is what we do. All right. So to me, I was not surprised when the jury returned a first degree murder conviction for him, because especially with him, as soon as he got to the apartment that day, he uploaded the very first thing. He didn't trash the apartment first. What he did first was he started a Discord chat to his phone to spy on Anna, which he shouldn't have done that. He shouldn't have done that. And that's the other hard part for his daughter, to, like, it was her iPad. Why put your child in the middle like this? Like, that's just so problematic. So, yes. Always talk to a lawyer, but just don't do crimes. Don't do crimes. Don't do crimes. He did that that courthouse interview that Ali Abulaban did, where he's screaming. The audio is horrible on that. I did cover a portion of it. So I don't like when people yell. I would not see him in therapy. Like, so if a person like him presented for therapy, the way that he needs to let things out is triggering for me. And I would not do therapy with him. Because there's certain cases I don't see because they're not a good fit. And I do work with explosive people, with explosive males. I see them building. It's like a predictable explosive, or if it is like, if it does come out of nowhere, it's normally a teenager that I'm working with, and it's a parenting thing, and they're more likely to like explode at their parent than me, and I might do family therapy. But my clients, they always know, if you get really upset in session, there's the door. Like, you can walk out. Like you don't now. And if they elope, I'm gonna call the police. Like, I'm not running after people. I'm not, nope. And I have the parents there. Like, I'm gonna strategize with the parent. How do we handle this? My office is up the street from a psych hospital. Like, I'm just like, I'm not, no, like, you do not. And I tell my clients, I press charges. Do not put your hands on me. Like, no, that's a crime. I don't put my hands on you. You don't put your hands on me. Those are crimes. You get really upset. I have a weighted blanket. I have kinetic sand. I have stress balls. I have all the things. And you can literally get up and leave. You can say, F you, Dr. Berry, and walk out the door. And I'll just be like, I'll see you next week. Like, I don't think I'm not, I don't force people to be in my office. I typically don't see a lot of court-ordered therapy clients. I have done court-ordered psych evals. I've stopped those. I'm just not a fan. I don't really like them. It's a lot of work. It's good money, but because they have to pay out of pocket. If it's court-ordered, insurance doesn't pay for it, and so they pay my full out-of-pocket rate, which is nice, but it's just not worth the possible court appearance, which they still have to pay me for that too, but it's just not worth it. I don't like them. Just don't do crimes. Just don't. Like, and it's not that there are more crimes happening. So more courts are allowing TV and cameras in for us to see it. Okay, so y'all tell me in the chat, should we watch the guy that streamed, like that signed into the Zoom call driving, and what he was appearing for was driving on a suspended license? Let me know in the chat. Should I play that really quick? The video, the guy that that did that. There's a great question, and I will cover it. Let me see. So have I ever? So normally, what happens? Some people, because anger is a stress response, and I'm incredibly likable. Like, so I've had clients threaten themselves. I used to do intensive home-based therapy, and I used to work in residential very briefly, very, very briefly in residential, 6 months, because I was getting attacked on a regular basis. It was not fun. And I didn't feel like it was helpful. And so I left that. Okay. We're gonna cover the guy that that did the thing. So I do not so I've never the one thing I will say is I had some weird calls to my phone where I think there was something shady happening, and I terminated with the client because I didn't feel comfortable working with them. And I was willing to, like, hey, I'll work with you until you get another therapist, but I don't think this is a good fit. And the person just didn't come back, which is fine. But I don't normally get I normally don't get those types of situations, because so like a client can come in and they can sit on my couch and go to sleep, and I'm not going to force them to be awake. I do not do couples therapy is extremely hard. So couples have every right to divorce. And normally when couples are coming to couples therapy, it's for one of a few reasons. Number one, there's a problem in their marriage and they really want to work on it. Both of them do. Number two, this is the last thing they're doing before they get a divorce. Number three, somebody is doing this just for the other person because they already have both feet out. And so couples therapy, it's just, I don't like it. So I don't do it. I work with families. I work with individuals. I work with kids and teenagers. It's much more helpful to work with the adults. And so that's what I do. I'm pulling up that video. Suspended license Zoom court. It comes up right while driving. Okay. Like we have to see it. We have to see it. Like, you just can't make this stuff up. You can't make it up. You can't make it up. And so let's go ahead and watch this right here.
Defendant is turning himself into the Washington County Jail by 6 p.m. today.
So this is the end.
Assistant Public Defender Natalie Tate for Mr. Harris, who should be present via Zoom.
Mr. Harris.
Okay, so Mr. Harris is at the bottom. Judge, the Honorable Judge Cedric Simpson, and then the probably district attorney is right over here. Okay, so that's, oh, and I'm probably pointing wrong because I'm in reverse. So, okay, it's just I'm not going to try to point. I'm not going to try to point at the people. So you can see the judge. The person on the bottom is the defendant, like the person who's there for court today. I'm going to make sure that we're on normal speed. Perfect.
Are you driving?
Actually, I'm pulling into my doctor's office, actually. So just give me 1 second. I'm parking.
I'll try to make that go away
right now.
Hey.
I think the judge just
You
realized.
Stationary?
I'm pulling in right now at this second. Yes, I am.
All right. What are we doing?
Your Honor, we are respectfully requesting an adjournment in this matter, up possibly 2 to 4 weeks if the court would allow.
Okay. So maybe I don't understand something. This is a driving while license suspended,
That is correct, Your Honor.
and he was just driving. And he didn't have a license.
Is with the charges, Your Honor, yes.
No, I'm looking at his
Yes.
record. He doesn't have a license. He's suspended and he's just driving.
That is correct, Your Honor.
Hello?
1 minute, Mr. Harris.
I don't even know why he would do that. So defendant's bond is revoked in this matter. Defendant is to turn himself into the Washington County Jail by 6 p.m. today. Failure to turn himself in will result in a bench warrant with no bond. Thank you.
Thank you, Your Honor. Mr. Harris, I'll be giving you a call.
Okay.
Court calls the case, People versus Maya Isom.
So, yeah. Hey, mama. That's my real life mama. Hey, mama. He is sitting in here because the car was moving when he logged in for the Zoom. Sir, are you driving? Give me a second. I'm just pulling into my doctor's office. That's not a reason to drive. And that's hard. So when their license is suspended, that is difficult. Sometimes they will say, like, on certain licenses, you can sometimes drive to work sometimes, but I think his is fully suspended and he's not supposed to be driving at all. He's not supposed to be driving at all. And he logs in for his court appearance driving. So, like, I was saying, like, there's not a, but like, they record these things and they put them out on the internet and we cover them. And so, but somebody said, how could he be that incompetent, or like, how could he do that? The prosecution wasn't even saying, like, hey, judge, this is unsafe. Like, we should go ahead and press some, like, the judge was the one that decided, I'm revoking his bond. Like, that's literally why we're here, because he was driving without a license. He logs into Zoom driving without a license. And so it was completely the judge's decision. And so oh, what? I'm not a cat. Oh, wait a minute, but that's an old one. I love that one. So I think that's the lawyer that somebody probably put a filter on his Zoom that said that he was a cat. I remember that one. Yes. I haven't seen Bruce Willis cover it yet. Bruce Rivers. I haven't seen Bruce Rivers cover it yet. And I had to sing the song. Bruce Rivers, he's a criminal lawyer. Like, I had to sing the song to figure out his name. I'm bad with names. I am so bad with names. And so, all right. Thank y'all for being here. I so appreciate each and every one of you. If you haven't liked the video, go on ahead and give it a quick like. It helps with the whole algorithm stuff. I'm going to go back and add timestamps. Today we covered a lot. And so if anybody wants to skip ahead just to that particular section, I'm going to go back and add that a little bit later. I so appreciate you all. On Tuesday, we've done all the things this week, all the things. And so I'm going to figure out what we're going to talk about next week. We might just do like a mental health stream or something. I don't know. Like, I'll figure out what we're going to do. And but I appreciate you all, and I hope y'all enjoy the rest of your weekend. Bye.